Good morning. It's Sunday, October 9th. And coming up before the Supreme Court in this term is an attack on the Voting Rights Act of 1965. And this attack is coming through the state of Alabama, which had redistricted its population in a way that seemed to discriminate against the 27% of the population in the state that is black. And I am ready to admit that we suffer from gerrymandering in this country, but I'm also ready to submit that creating voting districts that are fair to all people in the state is an extremely difficult job. And if you understand the history of voting in the United States and the discriminations that had to be overcome in several different stages, you can appreciate the tasks in front of the people that are responsible for creating the voting districts. Because if you look at the history of voting in the U.S., you can see that we developed over the course of 250 years significant changes to the way people were allowed to vote, who was allowed to vote, etc. Listen to this. White men aged 21 and older who owned property were given the right to vote in 1776. That's how we started voting. And then the 15th Amendment to the Constitution removed racial barriers to voting in 1870. But states continued to practice voter discrimination and continued to deny black voters a chance to participate in elections. And that's all after the Civil War, and everything was supposed to be hunky-dory. But you know that's never the way it is in the United States. And then in 1920, the vote was extended to white women. Not all women, white women. Now, I never realized that they specified that white women were the voters in 19. But somehow or other that didn't seem to matter, because I think all voting was taken care of after that anyhow. And it wasn't until 1965, because of years of intimidation, murders, and other acts against the minorities, primarily the blacks, that the Voting Rights Act was passed. And that cleared the way for black people to vote more easily. But it was still a struggle, and it still is a struggle to this day. And then 1965, that was supposed to be the end of it, but that wasn't the end of it, because there were several other provisions that were extended in 1970, 1975, 1982, and in 2007. Things that were left out of the Voting Rights Act were passed during those years. And all of those passages, all of the things that passed, were enforcement measures, requirements for certain jurisdictions with a history of disenfranchising voters. They had to obtain approval, pre-clearance from the U.S. Department of Justice or the District Court in D.C. before they could make any change to voting practices or procedures. So that's in place. It's not like a state can change anything without getting somebody's permission. Although they probably ignore that to a great extent. Because you're not allowed to infringe on the right to vote on account of any race or... And that's what this case in Alabama is all about. People of color being disenfranchised. So to understand the problem, let me tell you this. Alabama has 2 senators like every other state, and they have 7 congresspeople. 7 representatives, 6 Republicans, and 1 Democrat. And they have chosen to draw up a new electoral map. And that's the problem that the Supreme Court is going to settle. And whatever decision the Supreme Court comes to will affect the nation. And let me give you some of the particulars associated with the crux of this case. The population in Alabama is 27% black. And the majority of those blacks live in Montgomery, Alabama. Montgomery has a large black population. And so in previous maps, that one representative who came from the area of Montgomery would be a black person, probably. But with the new census in 2020, the state of Alabama has redrawn the maps. And they claim that they have drawn the maps in order to equally distribute the population densities. The result of that is that much of the black population in Montgomery was dispersed into more than one district, which will radically change the voting overall. And the claim that the map drawers of Alabama have made is that this is a majority-minority map and it's equally distributed across the entire state. But the black voters were unhappy with this decision and they challenged the new map. They claimed it cracked their community and deprived it of the ability to get representation for the community, which was the intent of our system of voting for our representatives. So if you take the black community and you spread it among the majority white community districts, then you have effectively silenced the minority vote. The redistricting will perpetuate discrimination, and that violates Section 2 of the Voting Rights Act. And so that's what we're going to see in the Supreme Court this session. So if the Supreme Court allows Alabama to run with its redistricting plan, and it does not see the challenge to Alabama's redistricting as a threat to the United States, then the Voting Rights Act essentially will be in the trash can. If you take a look at the big picture, you must realize that redistrict should not be in the hands of the state legislatures. It should be run by independent groups that have no axe to grind in any given state. That would be a nice thing to put in, to create an amendment or a law for that. So I leave you with those horrible thoughts this morning, and I'll see you tomorrow. Bye.